This week I will be discussing the Fifth Amendment. With the Fifth Amendment, it is defined as no person shall be held to answer for a capital or otherwise infamous crime, unless one, a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled to, in any criminal case, to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. The Fifth Amendment is a constitutional right. It protects individuals from incriminating themselves. Any questions that is asked that can be used to prosecute you, you have the right to not answer those questions. The Fifth Amendment was put in place to conserve those rights. With self-incrimination happens when an individual exposes involvements with crime, which can be intentional or unintentional. The Fifth Amendment provides protection for witnesses who must testify in incrimination happens while giving a testimony. Popular term is plead the fifth. Plead the fifth happens when an individual happens to refuse to answer the questions that may incriminate them. Now, when you are arrested or accused of a crime, knowing what questions to answer keeps away from self-incrimination. Pleading the fifth is simply letting officers know that you refuse to answer questions and you are using your right to remain silent. Any questions asked at this point becomes inadmissible, which basically means it's thrown out. With steps that officers may take to gain incriminating statements admissible into a trial. According to Fine Law 2023, law enforcement officers must inform suspects of their remand rights, to remain silent, and to have an attorney present. As long as the suspect understood these rights as explained, statements made in subsequent interrogation may be admissible as evidence against the suspect if he or she did not clearly invoke the right to remain silent or the right to an attorney. In order for an individual's statement, to be considered inadmissible, prosecutors must prove that statement was taken by using force or threats and done unlawfully. As a citizen, you do have the right to remain silent and stop answering any questions asked by officers. At this time, any statement taken cannot be used in court. Now, if your Miranda rights are given and an individual decides to invoke the right to remain silent or to an attorney, then at that time any questions asked become inadmissible. If a witness obtains an attorney and agrees to provide a statement, at that time that statement can be used as evidence. For the remedy for a defendant when a motion to suppress is granted for violation of the Fifth Amendment. To constitute a constitutional violation, the law enforcement technique must be so outrageous that it is fundamentally unfair and shocking to the universal sense of justice mandated by the due process clause of the Fifth Amendment. The remedy for a defendant when a motion to suppress is granted for violation of the Fifth Amendment is grounds for dismissal of the case. Miranda rights at this time has been violated, and any evidence obtained is admissible, giving the court no case. When motion to suppress is granted for violating the Fifth Amendment, this can result to dismissal of case. As previously said, rights are essential and are not to be taken lightly. If a prosecutor proves that statements given was done against government actions or was done forcefully, then terms for dismissal of the case at that time is done. That would be considered the remedy in regards to any motions to suppress and granting for violating the Fifth Amendment. Next, I just have my listing of my references, which I did use 3 references in regards to my presentation. Thank you.